observations about the role of the Select Committee, and then I will address firstly what happened in Gauteng, secondly what happened in the Western Cape, thirdly the consequences of these events, and fourthly remedy and costs. So the Select Committee, it is the engine room of the NCOP in relation to legislation, and it is the body that conducts the public participation on behalf of the NCOP. It receives public submissions made to the NCOP. It receives reports of the provincial legislatures. It receives briefings from the department, and it then considers and decides whether any amendments should be proposed to the NCOP plenary. The Select Committee conducts the entire public participation process on behalf of the NCOP. So if there is no other public participation process in the NCOP, and so if the Select Committee fails to conduct public participation in the manner required by the Constitution, then the NCOP has failed to conduct the public participation as required by the Constitution. So let me start then with what happened in Gauteng. This court held in Doctors for Life and Mogale that the NCOP is entitled to facilitate public participation through meetings held by the provincial legislatures. The court has held that the condition for this is that it must be done in such a way that the public hearings are capable of influencing the outcome, and that means that the views and opinions expressed at the public hearings must filter through to the NCOP, in other words, the Select Committee. If the court has held that if public participation is not accurately and comprehensively transmitted to the NCOP via the Select Committee, this deprives the process of the potential to achieve its purpose. The filtering through to the NCOP can be achieved in one of two ways. Firstly, it can be achieved by giving the NCOP reports on what happened at those hearings. Alternatively, members of the Select Committee can personally attend those hearings and then inform the other members of what happened there. It's common cause that the NCOP was not given any report on the public hearings in Gauteng. The Minister repeatedly asserts in somewhat airy terms in his heads of argument that this doesn't matter because the relevant members of the Select Committee attended the public hearings in each province. But there's no evidence at all to support that proposition, none. First, the Minister doesn't say on what factual basis he makes this conclusory assertion that there were the relevant members at every meeting. He doesn't say how he knows this, provides no evidence. Secondly, the Minister in fact admits that he doesn't know what happened because the only evidence of this on affidavit about this issue is what he says in paragraph 113 of his answering affidavit. It's at page 00-86. He says the following, quote, "All 60 meetings, if not the majority, held within the provinces by the provincial governments were attended by the respective permanent members of the NCOP. All 60 meetings were attended, if not the majority." So he doesn't know whether in fact all were attended. He sort of pleads the facts and the alternative. He doesn't really know who was at which meetings and how many were attended. On his own evidence, he doesn't know. Of course, it would have been the easiest thing in the world. The issue is Gauteng. Did anyone attend the Gauteng meeting? And it would have been the easiest thing in the world for the Gauteng permanent representative, Mr. Bacha, to file an affidavit saying, I attended all the hearings in Gauteng. But he doesn't do so, and his silence, we submit, is deafening. The Minister also, so there's no evidence to show that the Gauteng representative was there, and the person who can give that evidence doesn't do so. Secondly, the Minister also effectively admits that the Gauteng permanent member didn't report orally to the Select Committee on what happened in the Gauteng provincial hearings, because he says in his heads of argument at paragraph 101 that's at page 0066.2, he says, other members could have raised questions with the Gauteng member relating to the public hearings in Gauteng. In other words, the Gauteng member didn't say anything, but they could have asked questions if they were interested. That's not the way that public hearings are conducted and reported upon. And again, if the Gauteng permanent member, Mr. Bacher, did provide information orally, he could have made an affidavit and said so. Said, I attended the meetings of the portfolio of the select committee and I told them exactly what had happened. Again, his silence is deafening and there's no explanation as to why he, who's the only person who can give this evidence, doesn't give it. And we also draw the court's attention to the fact that the minutes and the reports of the proceedings of the select committee do not reflect any report of any kind in respect of Gauteng. So what happened at the Gauteng public hearings was never communicated to the select committee. We asked the court to consider what the position would have been if there had never been any public hearings in Gauteng. We say if there had never been any public hearings in Gauteng, that would have been fatal to the NCOP process. And it would not have been, as the respondents suggest, an odd defect at a particular meeting. This is no meeting at all. No meeting at all. If there were no meeting at all, there would have been a failure to comply with an essential element of the duty of public participation. And we make the submission that this is in effect what happened, because the NCOP was not informed of what had happened at Gauteng. In effect, it was as if there was no public participation at all in Gauteng, because there was no report at all about public participation to the select committee. Members of the public were therefore unable, in Gauteng, were therefore unable to influence what happened. And in the words of this court, this deprived the process of the potential to achieve its purpose, namely that the public ought to be able to affect the outcome. So that's what happened in Gauteng. And I'll come later to the consequences. Then what happened in relation to the Western Cape? On the 21st of November 2023, the Select Committee adopted the bill. It did that without the report on the public hearings in the Western Cape, and it did that without the final mandate of the Western Cape. Those two critical elements of the process were missing. At that meeting, the committee discussed the absence of the Western Cape delegation and mandate. And in the words of the report, which one will find at page 004-1596, the chairperson, quote, said that the previous meeting had dealt with the issue. It was proposed that the meeting dispose of the issue. So it was left there. The meeting went ahead and the committee adopted the bill, having never had a report on the public hearings in the Western Cape and having never had a final mandate of the Western Cape on the bill. And there is nothing in the meeting, report of the meeting, or in the affidavit subsequently filed to suggest that this meeting of 21 November and this decision was a provisional decision. The minutes show it as a final decision. The committee made a final decision to adopt the bill, and there's no evidence to suggest otherwise. But then something unexpected happened in the week that followed. It's not explained. It was decided to hold a further meeting on the 28th of November, a week later. And the stated purpose of that meeting was to consider the Western Cape negotiating and final mandates. And so the committee met again on the 28th of November, 2023. By then, it was too late for the Select Committee to consider the merits of what the Western Cape Provincial Legislature was proposing, because the plenary was going to take place the next day. It was the day before the plenary. There was no opportunity for the members of the Select Committee to go back to their provinces and say, Western Cape, consider this, I've proposed this, what do you think, what should our position be? Because the plenary was going to happen the next day. There was no opportunity for the Select Committee to do what this court explained is the purpose of the exercise, namely that the provinces get together and discuss together what their approach should be. They share information, they share ideas. It's not just sending in an email saying, I'm for, I'm against. The whole purpose of the exercise is to give them an opportunity to debate what the different provinces feel about it and to take a view on the matter from the view of provinces. That couldn't happen. And so the minutes of the meeting of the 28th of November explain what happened. It's at 004-1598. First, the committee received the negotiating and final mandates of the Western Cape Provincial Legislature. Then there was some discussion about why the Western Cape mandates were being considered at that time. There was no discussion of the Western Cape proposals, none. And the committee then adopted the bill exactly as before. The entire meeting took 35 minutes. And that's the outcome of the Western Cape public participation process. That's the impact that it had on the process. In other words, nil. And the next day, the plenary approved the bill. We say, unsurprisingly, the respondents seem to place little weight on this last-minute attempt to patch up the problem by holding a meeting on the 28th of November. And that's for two reasons. Firstly, by then, the committee had already made its decision. It had adopted the bill. And secondly, there was no discussion of the Western Cape mandates, mandates and amendments. They were never discussed. In other words, this was simply a rubber stamp exercise. It was a belated attempt to cure the problems arising from the previous meeting and to nominally tick the box of considering the Western Cape public participation and the Western Cape mandates before the next day's plenary meeting. And we say, without wanting to be abusive and rude, it was simply a charade. So then what are the consequences of these events? The consequence we submit is that in 2 of the 9 provinces, the process failed. There's no getting away from that and from the results that follows. In 2 provinces, the public participation process failed fundamentally, not in a trivial matter, a trivial respect. It failed to happen as is required by the law, and the process, it failed. On the papers, there is some blame game about who's responsible for what happened in the Western Cape. And we submit that that's not really a helpful debate. The question is not who is to blame. The question is whether, and the question which the court has said is the guiding question, is whether the NCOP acted reasonably when it undertook the public participation process in this manner. And 3 issues arise from the manner in which the Select Committee did this. Firstly, as we've said, the Select Committee met on the 28th of November, supposedly to consider the Western Cape final mandates. But what this means is that there was, in fact, more time available for further debate than the NCOP had suggested in the correspondence. There was a whole week from the meeting of the 21st of November to the 28th of November, and so there was some time available. The meetings are virtual. There's no need to set aside time for travel and for people to gather. There was, in fact, more time than the NCOP suggested. Secondly, the only reason which was given at the time of this refusal of an extension, was the refusal to extend the deadline for submissions, is at page, you'll find at page, can I ask the court to go there? It's 006-39. Is the system working? Well, I'll just read it to the members of the court. It's at 006-39. It's a letter from the chairperson of the Select Committee to the chairperson of the NCOP, and it's about extending the period for the negotiating mandate. And what the letter says is the following: the Select Committee has thus extended the negotiating mandate and final mandates. I'm sorry, this is a letter dated 8 November. Has extended the negotiating mandate and final mandate dates by 2 weeks already. Unfortunately, any further extension will result in the delay of the finalization of the NHI bill. It would mean the NHI bill legislative process would not be finalized in the current calendar year. And I'll draw the court's attention to that. That was the focus, was finishing it in the current calendar year. It said we won't be able to do it, therefore we can't grant an extension. Now, there's no explanation of why the calendar year was an immovable deadline. What was the magic of the 31st of December? What was the magic of 2023? The Parliament was going to continue sitting in the early part of 2024. Why couldn't it be done then? But their focus was, and the reason given was, the contemporaneous reason was, we have to finish it in 2023. It's immutable. That's exactly what happened in the previous cases the court has previously dealt with, particularly in Lamosa, where there's a deadline set, an immutable deadline is set and not explained. So that's the third thing. Why the deadline of the end? Second thing, why the end deadline of the calendar year? Thirdly, to the extent that there was a concern about finishing the bill before the end of Parliament's term, because that's what's raised in the answering affidavits. In the answering affidavits, the respondents say it had to be finished within the term of this Parliament, which would rise in the early part of 2024. Then, like in Lamosa, there's no answer at all to the question which this court raised in Lamosa. The court said the following, if I can, at paragraph 66 of its judgment in Lamosa, and I quote, "Why did the NCOP not allow the bill to lapse and subsequently invoke its power to reinstate it under Rule 238.1? No cogent reason was given." I'll just read it again. Why did the NCOP not allow the bill to lapse and subsequently invoke its power to reinstate it under Rule 238.1? No cogent reason was given. That is exactly what happened in this case. There's no explanation at all of why the bill had to be concluded in that session of Parliament. And the result is that the decision to limit public participation, to have a timetable which limited public participation in this manner, was unreasonable. Like in Lamosa, exactly the same. It was the result of a fixed adherence to an immutable deadline for which no justification has ever been offered. And as this court pointed out in Doctors for Life, at paragraph 194, the timetable must be subordinated to the rights guaranteed in the Constitution, not the other way around. The rights don't give way to the timetable gives way to the rights. In Lamosa, the consequence of this failure was that the act was not validly enacted. Then I need to deal with the criticism under this heading of the consequences, the criticism of the Western Cape Provincial Legislature. Again, I'll come back to the legal consequences in due course. There was a late affidavit filed last month by Mr. Ndevu, who was the chairperson of the Select Committee and a representative of the governing party. He made a belated affidavit last month, and when you read it carefully, what he does is he insinuates that the Western Cape Provincial Legislature asked for an extension only because it knew, only when it knew that on the 2nd of October a final deadline had been set and it was attempting to obstruct and frustrate the finalization of the bill. He says the meeting was held on the 2nd of October, you then requested the extension, and he implies this was an attempt to obstruct and frustrate the finalization of the bill. That affidavit is answered by Mr. Pretorius, who was the chairperson of the Western Cape Provincial Legislature Standing Committee. And he explains as follows. His affidavit is at 006-74. He says, the last scheduled public hearing in the Western Cape was held on the 29th of September. The meeting was so well attended that the venue was overflowing. Members of the public requested that additional public hearings be held. He says the provincial legislature had previously been inundated, that's his word, with similar requests for further public hearings. And so he says that immediately after the hearing of the 29th of September, he reported this to the chief whip. and they discussed the matter, and they agreed that additional public hearings should be held. That was immediately after the 29th of September. And this was, he says, was before the supposed meeting of the 2nd of October when the final timetable was fixed. He says that when he wrote to the chairperson of the Select Committee asking for an extension, he hadn't been informed that the date of 27 October was a final, fixed, immutable deadline. And he says if there was a meeting on the 2nd October, and I should say, it's very odd, there's no minute of that meeting. The meeting doesn't appear on the schedule of what the committee did and the schedule of the committee's meetings. There's no record of it. There's just an averment that it was held. But assuming it was held, if there was a meeting on the 2nd of October, he was not aware of it, and he says that he believed in good faith that further public hearings were necessary in the Western Cape. And we submit that all of this destroys the insinuation by Mr. Ndevu of a sinister or ulterior motive in requesting an extension of the deadline so that further public hearings could be held. It was for legitimate purpose, which was to achieve further public hearings, which had been demanded and repeatedly demanded in the Western Cape. Thereafter, the Western Cape provincial legislature tried repeatedly to obtain an answer from the NCOP as to whether that extension would be granted. It had no success for, I think, 2 weeks. Finally, by the time an answer was finally received, they had had to make the necessary arrangements for the meetings and give public notice of the additional hearings. Now, one might say, despite all of this, that the Western Cape provincial legislature could have acted more speedily in some respects. Maybe that is the case. But whether that's the case, that surely can't be held against the members of the public who wanted to take part in the public participation process and they wanted to be heard. They can't be non-suited if the Western Cape provincial legislature didn't act as speedily as it might have. So that's the question of the blame game. I need to say something also about the dangerous precedent. The Speaker says a dangerous precedent will be set if a province is allowed to bring about a delay in this manner. And we say with respect that's the wrong question. The question is whether the Select Committee acted reasonably. If the Select Committee did not do its job reasonably, then the NCOP did not do its job reasonably, and that's the end of the matter. Conversely, if the SC did do its work reasonably, that's also the end of the matter. The NCOP decision stands, and that's the question. It's not a question of dangerous precedent. And I can't resist saying what an English philosopher once described as the rule of the dangerous precedent. The rule of the dangerous precedent is, I should not act justly today for fear that I may be expected to act justly tomorrow. That's what the dangerous precedent means. Don't do the right thing now, because I might have to do the right thing again tomorrow. The right thing would have been to give an extension. So that brings me then to the question of remedy and costs. And the precedent as far as remedy is concerned was set by the court in Doctors for Life and in Lamosa. Doctors for Life was decided in 2006. The court said at paragraph 213 that if either the NCOP or the National Assembly fails to fulfill its constitutional obligations in the lawmaking process, the result is that Parliament has failed in its duty, and the matter must be remitted to Parliament to reenact the law in a constitutionally compliant manner. And may I just interrupt myself to say, however well the National Assembly does, can't cure the defect in the NCOP. Parliament, this court has made it clear that each of them, the National Assembly, however well it's done in the National Assembly, that can't cure the NCOP. The court has made clear repeatedly that both NEA and the NCOP independently must do what is required of them. One can't fix the other. So Doctors for Life, the court said the result is that the Parliament has failed in its duty and the matter must be remitted to Parliament to reenact the law in a constitutionally competent manner. Lamosa was decided in 2016. In that case, the court said at paragraph 82 that a failure by the NCOP, quote, taints the entire legislative process and it is a lapse by Parliament as a whole, close quote. So the whole process is tainted. And La Morsa is, again, with respect to close analogy, in La Morsa, what happened was a failure of public participation in the NCOP. The bill had been enacted, like here, the bill had been enacted, it had been signed, it had not yet been brought into operation, and now the matter was before this court. And the court found that the NCOP process had failed. The court simply set aside the act. There were various transitionary provisions, I don't need to deal with them here. And so we say there doesn't seem to be any obvious reason for departing from this precedent. And we address the matter in our heads of argument from paragraphs 134 to 143. But we say, we recognize that there's been a substantial process in the National Assembly, and it may be that the court will hold that that's a reason for deviating from the precedent. If there is, then we submit, at the very least, the full NCOP process should be repeated, and this time the Select Committee should do its job and do it properly, no doubt with guidance from the court as to what it had done wrong and what it needed to fix. Finally, as to costs, not finally, pre-finally, as to costs, the appropriate precedent seems to be Minister of Police versus Premier Western Cape. Again, a dispute between the provincial and the national government. It's 2014, 1 SA, 1 CC. And the court held, paragraph, I think it's paragraph 72, that the ordinary rule in litigation between spheres of government is that no order for costs is made, whatever the outcome. Each bears its own costs. Then, genuinely, finally, may I say something about the merits again. Our client is genuinely perplexed and aggrieved by what happened. It is expert and experienced in this field. It knows what it's talking about. It put a huge amount of work into this. It undertook a detailed analysis of the bill, clause by clause. It made detailed proposals for amendment, clause by clause. It's the only provincial department that did that. Yet when you read the minutes and the record of the Select Committee, you see that these detailed proposals were never considered by it. All of this analysis, all of these proposals were ignored and are answered only with a generalized and airy assertion, well, the committee was aware of the general themes, and the general themes were answered by the department. We say that's not good enough for a bill of this scope and importance. And if we can, I haven't got the time to go there, but can I just give the court we have set out in detail what wasn't considered. It's an answering affidavit, paragraphs 126 to 131, page 005-38 to 005-400, and paragraphs 267 to 271, 005 to 70 to 005-73. Of course, it would have taken some time for the Select Committee to do all of this, to consider all of the amendments and take a view. But that's what it had to do. That was its job. Just as the Portfolio Committee did. The Portfolio Committee did extensive work on proposed amendments and proposed a large number of amendments. If you want to see them, you'll find them at 004-418. That's what the Select Committee was required to do. It's simply not enough, we submit, for a bill of this scope, a bill of this complexity, and a bill which affects the right of everyone in South Africa, for the public participation process in the NCOP to be as cursory as this was. No consideration of the submissions, never any consideration of amendments, no debate. Respectfully urge the members of the court to read the minutes of those meetings of the SCA, of the Select Committee, the meeting about the negotiating mandates and the meeting about the final mandates. The astonishing thing you will find there is no discussion whatsoever of the merits, no discussion whatsoever of submissions, no discussion whatsoever of amendments. That's not good enough, and particularly we submit for a bill of this sort, which is going to change the lives of all of us, every one of us, in this court and outside this court. Chief Justice, those are our submissions. On the bell.
Thank you, Mr. Badlinde. Questions, colleagues?
Thank you, Mr. Badlinde. Just a few questions from my side. In assessing and in determining reasonableness, and Mohale and Lamosa are instructive in that regard, must one have regard to that which was not done, which you've captured quite eloquently and substantively, but also have regard to that which has been done? To what extent is the approach to look at it cumulatively, as I think Mohale says? One looks at it in totality. Because that would mean, and I'm not sure if you agree, that ultimately on the fact-specific case of what's before us, the court must make an assessment as to whether the conduct of the NCOP was reasonable with regard to the totality of what occurred. One could arrive at different answers if one took a different approach. If one simply insulated everything else that happened from that which didn't happen, it may lend itself much easier to a conclusion of unreasonableness, as opposed to looking at it in totality, which may, I suppose, in your view, still lend itself to the same conclusion, but it's important conceptually that we get the starting point right. So let me start with that question.
Yes. Justice Colopin, I submit that it is correct to look at the whole picture. Reasonableness must be viewed in the broad. But that's subject to a qualification, which is that the law, as explained by this court, is that there are some immutable elements of the process. If the process is very good in certain respects, but one or two key things which are essential and immutable are not done, that upsets the apple cart. And so while it isn't a broad, overarching consideration, you have to say, are there any showstoppers here, which mean that it can't be approved? We submit that is the case in this matter, because in two provinces, there was a fundamental failure of the process.
Good. Just arising out of that, then, would one accept as a consequence of a public participation process that there may be voices that will not be heard? And that's not necessarily dispositive in answering the question whether the process was reasonable. And then following up on that, there is a dispute factually, it appears, with regard to whether members of the select committee attended the Gauteng hearing. The minister says they did, but he doesn't give details. What are we to make of the minister's statement under oath that they did, mindful that, well, there could be better evidence submitted with regard to this? But if we have to take that for what it is, then are we entitled to assume at the very least that if those members attended the Gauteng hearing and absent a report, those members being present at the select committee would have achieved what the case law speaks about, the linking mechanism between what happens at the provinces and what happens at the select committee?
Thank you, Justice Colopin. Yes, there will always be some voices that are not heard. But the rule laid down by this court is that those that take the trouble to make their voices heard must be heard. Those that come to the meetings must be heard. You can't say, well, bad luck for you. The question of a dispute of fact.
Could I just ask you on that one? In the context of the Western Cape, it appears that, well, the Speaker takes the position that the additional public hearings were to be held in districts where public hearings had already been held, and I know there's a difference in the location.
Yes.
But would that be purely unreasonable, the refusal of such a request?
Justice Colopin, it's not a matter for the chair of the NCOP to decide where the meetings are going to be held in the Western Cape. That's a provincial decision. With due respect, it's a complete overreach for the chair of the NCOP. I say, well, if you'd said it was going to be heard in somewhere else, I would have agreed. But because you say it's going to be here, I don't agree. That's not something which is within his power and his jurisdiction.
And arising from that, Mr. Butlander, would you then say that if it's for the province to decide on where and how many public hearings
Yes,
are to be held,
yes.
that whatever consequences that has on the timetable of the National Assembly and the NCOP must be accepted as a consequence of that decision? Or how does one relate to each other?
Now, I wouldn't go that far. I wouldn't say that wouldn't submit that the province made us say we're going to have 100 public hearings and that's going to hold the whole matter up for 3 months. There is a question of reasonableness in that sense. The reasonableness in this sense is, so reasonableness, it's not for the chair of the NCOP to say you can have it in Swellendam, but you can't have it in Stellenbosch. You can have it in somewhere else, but you can't have it in Paarl. But if the select committee, if the provincial parliament does something bizarre, unexpected, then the NCOP is entitled to say, well, we can't accommodate that. If there's a reason for not accommodating it. It wouldn't be enough if the provincial parliament said we don't want 5, we want 10, and it's going to take us another couple of weeks. We submit it would be reasonable for it to do so, and it couldn't be stopped. But if it says we wait for months, that would be different. But it is in the first instance for the province to decide how many public hearings will be held and where they will be held.
Sorry, Mr. Butlander, you were going on to the dispute of fact
Yes,
when I sidetracked you. Yeah.
Thank you, Justice Colopin. As far as the dispute of fact is concerned, for a dispute of fact to exist, there must be 2 contradictory forms of admissible evidence. For example, if there's evidence given under oath which is hearsay, you don't take that into account in deciding disputes of fact. There must actually be factual evidence, and we submit they must be primary evidence. This assertion by the chairperson of the NCOP that this happened is not evidence. There's no evidence of primary facts by somebody who's in a position to attest to those facts. There is no real dispute of fact. It's an apparent but not a real dispute of fact, because on the one evidence, no hearings. On the other hand, there's no evidence that it took place. It's just someone says, I say it took place. 2 further points in that regard. Firstly, one of them has slipped my mind. Firstly, let me say there was, in any event, no report to the Select Committee on what happened at the public hearings. If Mr. Bacha did attend them, there's no evidence to show that he ever reported to the Select Committee on what happened, and in fact the minutes suggest that he never did report to them. Secondly, that's the other point I wanted to make, the minister himself cast doubt on his evidence by showing that he doesn't know whether it happened. He said it happened in all of them, if not the majority. Well, which majority? Was Gauteng part of that majority? And how does he know that it was in the majority? It's simply, the evidence is, with due respect to him and his position, it's entirely unhelpful, because there's the one thing he doesn't say, in unqualified form, is that in Gauteng, the Gauteng member attended the public hearings. There's no evidence, even his conclusory statement can't take you there, doesn't get you there, because he himself says, well, it happened at least in the majority, but he doesn't say the majority included Gauteng.
Thank you, Mr. Butler. And then just finally, having regard to what did happen, which Mr. Maneche and Ms. Pillay took us through yesterday, and which I think the applicant certainly in BHF accepted was an extensive public participation process.
In the Assembly?
Well, also in the NCOP. What would your view be with regard to the shortcomings as opposed to what did actually happen? Even in the NCOP, would you say that the shortcomings were such that they militate against any conclusion that there was meaningful public participation?
Justice Colopin, I didn't understand BHF to say that there was extensive public participation in the NCOP. I understood them to say the opposite, but they didn't go into that because it was going to be
I'm
addressed
talking
here.
about the NCOP. Let's say there
Yes,
were public hearings.
I don't think the BHF said that there was extensive public participation in the NCOP. If they did, it would be a very surprising assertion for them to make. The simple fact is that it is as if there were no hearing held in Gauteng, because nothing from a Gauteng hearing filtered back to the NCOP, to the Select Committee. And secondly, there was not effective public participation in the Western Cape because there was an abridged or a limited timetable for no good reason. There was a limitation of the public participation for no good reason at all. No reason has been ever offered. And secondly, because of the timetabling, the outcomes of the public participation in the Western Cape weren't placed before the Select Committee until it was too late the day before the plenary was going to be held.
Mr. Badlander? My questions are more in line with what my brother Kolapen has just put to you. I ride on his back to inquire about certain aspects which I'm just about to put to you. One, if in Gauteng we have, I don't put it as high as that, we have the evidence of the minister, Mr. Baka, the chairman of the NCOP, purporting to confirm what transpired at the hearings in Gauteng. And if we examine what has been put forward as evidence, and if that does not meet the required standard of an acceptable evidence by the three officials in support of the Gauteng's position that indeed there was effective or public participation.
Can I answer that
Yes.
first?
Yeah.
Thank you, Justice Matopo. Firstly, there is no evidence of Mr. Bacha. That's our point. Mr. Bacha is the one person who presumably would have been there if it had happened, and he doesn't say, I was there. There's no evidence from him. The evidence from the minister, as I've said, is in generalized terms, it says nothing about what happened in Gauteng, except that we know that it says, that the minister says, I don't know what happened in particular meetings, because he says there were people there in the majority of the cases. And the evidence of the chair of the NCOP, of the Select Committee, he also says that members attended provincial hearings, but he gives no details and doesn't say how he knows it. So it's in generalized terms, and he doesn't say he doesn't say every Select Committee meeting, every public hearing was attended by a member of the Select Committee, which is what he would need to say to create a dispute of fact. If he had said that, then there might be some room for argument as to whether that's good enough. He was chair of the committee, maybe he's reporting what was reported to the committee. But he doesn't say that. He doesn't say there was always a member of the Select Committee present at every public hearing, and more specifically, he doesn't say there was anyone present there in Gauteng. And so we say that that doesn't create any dispute of fact, standing against the fact that A, there was no report made, no written report made, and B, there was no oral report made at the Select Committee. So in fact, even if Mr. Bacher was there, it doesn't help because he didn't provide a written report and he didn't provide an oral report to the Select Committee. It just doesn't, it takes one with respect nowhere. It's generality cloaked in ambiguity.
So if that is how you would urge upon us to treat that evidence of the three officials that I've identified as not amounting to anything that is of a credible nature, in your submission, that would mean that insofar as Gauteng is concerned, nothing much transpired, and if it did, no evidence has been put forward to substantiate what happened there.
Yes, Justice Muthuphula. No, if it did happen, no evidence to show that it happened, and no report to the select committee, which is the essence of the whole thing. No written report and no oral report. So even if it happened, it doesn't assist, because there was no report to the select committee on what happened at the Gauteng public hearings.
If you pair that with what happened in the Western Cape, that's my second part of the question. If you do come home on the Western Cape route as well, so you would have the Gauteng as well as the Western Cape. And if it's accepted, let me not say accepted, if it is shown that the same position, albeit in different circumstances, had happened in the Eastern Cape, Western Capes rather, sorry, where it was subjected to truncated timelines for no reason, according to your clients, and that would have a bearing on the NCOP. Now, then you would have a scenario where the two provinces that form part of the NCOP would not have had or would not have met the proper threshold required in the various jurisprudence that you've alluded to. Then what happens to the bill?
What happened to?
What happens to the bill, to everything that happened? How are we going to unscramble this egg?
Well, I submit that at the very least, the public participation process would need to be repeated. Remembering, Justice Muthuphula, that one of the critical elements of the public participation process, it's explained by the court in Doctors for Life and in the other cases, is the essence of it is that each of the provinces hears what's happened in the other provinces, and they sit together and they discuss it. And each of them hears what the other is proposing about amendments. None of that happened. So the public, it would be very difficult, we submit to, you could conceptually say, well, the public participation process must be repeated in Gauteng and in the Western Cape, and thereafter the select committee must meet and consider the reports of that public participation process and the amendments which are proposed by the various provinces, and then come to a conclusion on the bill. That is the minimalist approach, to say repeat the public hearings, public participation in two provinces, and then the select committee must go do its process over again. Consider the mandates, consider the negotiating mandates, go off and take instructions, discuss the proposals made by the different provinces. Some of the provinces made quite comprehensive proposals, and consider all of that, and then decide whether to approve the bill as submitted, or to recommend to the NCOP to approve the bill as submitted by the Assembly.
This would be your fallback position.
Yes, that's a minimalist position, Justice Muthuphula. But we submit that it would be more sensible to have the whole thing, that whole public participation element, redone. It was really very unsatisfactory.
Now, BHF, you were here yesterday, seems to go for the killer blow. What I would want to know, is it possible in one breath to try and say, this is where we are going to start? We do the public participation insofar as in Gauteng and Western Cape. And on the other hand, we have BHF, which is going hammer and tongs to say there hasn't been compliance. So what judgment, if any, are we going to produce?
Well, yes, Justice,
you understand the dilemma that we are facing?
Yes, Justice Muthuphula. If the BHF complaint succeeds, then the entire public participation process must fail because members of the public did not know what it was that they were required to express an opinion on. I'm trying to summarize it. If the BHF approach succeeds, then it seems to me that the public participation process in both houses fails because of the failure to provide the necessary information. If they don't succeed, then, if I take it step by step, so if the BHF succeeds, all the public participation fails. Secondly, if there is a finding of invalidity in any one house, the normal practice is it goes back and starts again. But if the court, that's what happened in Doctors for Life, in La Morsa and in, I think, Doctors for Life was it, yes. Doctors for Life in La Morsa. But if one wants to take a more limited approach, if BHF fails, and if you want to deviate from La Morsa and Doctors for Life, then you can say, just repeat the public participation process in the NCOP. And then if you want to take a minimalist approach, you say repeat the public participation process in Gauteng and Western Cape, and then the select committee must do its job and must be explain to the select committee what it must do.
But if the BHF succeeds, it kills the entire bill.
Yes.
And does you know what comforts me from your submission is that, correct me if I'm wrong, you don't seem to be aligning yourself with BHB principal submissions that seeks to annihilate the bill. You are focused on the procedural aspects which you contend were not complied with. Would that be a proper summation of your submissions?
Justice Motopa, our brief and our mandate is a challenge only to what happened in the NCOP.
Yeah, that's comforting to me.
That's all we've raised in the pleadings. We can't now say, by the way, we agree with BHF. We haven't pleaded that case, and that's why we haven't entered upon it at all.
Does time and expense in the whole process matter, if any at all?
It bears, Justice Matupu, on what is reasonable in assessing what was done, and then it bears, I submit, also on the just and equitable remedy. The court is entitled, with respect, to have regard to time and expense in determining what is just and equitable, but always subject to the proviso that there must be effective public participation. The court can't, with respect, can't and won't say, well, it's too bad that there wasn't effective public participation. It's too expensive in terms of time or money to do it properly, so we'll just overlook that. We submit that could never be just and equitable.
So okay, let me conclude. So it means that a judgment of this court would take this form or shape. One, HF succeeds and everything starts de novo. Two, BHF fails. You succeed on the points that you made. Three, the applicants all fail. There can never be any middle course.
No, that's with respect so. And the question then arises, if only we succeed, what's the appropriate remedy to fix what went wrong in the NCOP?
Yeah.
Start again, or NCOP?
You can't succeed and BHF succeed. If you succeed, BHF fails. Would that be correct?
No, with respect, no, Chief Justice, Justice Matopo.
I'm not
sorry.
Chief,
My
Chief
apologies for the. Can I congratulate you on your promotion? If BHF succeeds, then let's go back to the
drawing
beginning,
board.
go back and start again. But the court will then have to decide whether it will nevertheless decide the NCOP challenge, the Western Cape challenge, would say that, well, this is now moot in the light of the BHF decision. And one knows what the principles which the courts adopt.
But I don't want to lose you there. If BHF succeeds, how can this court then say, you also succeed? Because if BHF succeeds, you can't succeed, vice versa.
We can succeed on a limited basis, I submit, Justice Matopo, because it's a separate case with a separate course of action.
I understand, I understand.
But you may say, well, it's moot. It's irrelevant now because the whole process is to start again. And so there's no need for us to worry about what happened in the NCOP. The problem with that, with respect, is that this NCOP is unfortunately a recurring problem. And it would be a good thing if the court explained to it that it really has to get its act together.
No, but if we explain it in the BHF judgment,
Yes.
we need not say much about the Western Cape's case, because BHF would have succeeded, and once it succeeds, the process has to start there. Would that be possible?
It's possible, it would be possible, and with respect defensible for the court to say BHF succeeds, NCOP, the Western Cape becomes moot, and we're not going to decide that question.
Well, I haven't thought about it. It just occurs to me as I'm talking to you now.
I say it would be defensible. We would urge against it, but there's a coherence to the argument. Let me put it that way.
All right. Thank you.
Thank you, Justice Matopo.
Thank you. Mr. Patlender, I think I'm piggybacking on the questions that were raised by my brothers, but I'd like us to go back to the beginning, the pleadings.
Yes.
In the pleadings, the province alleged that only 2 provincial legislatures had submitted public participation reports. And the NCOP in response, in fact, refuted that and said that, in fact, only 1 had not submitted. In other words, 7 out of 9 had submitted, as opposed to what the province had said. It had said 2 out of 9. Now, the case for the applicant has slightly changed. We are now dealing with what was not submitted to the NCOP. That is Gauteng not having submitted its report. Now, let's consider that, and what should we make of the fact that at the end of the meeting, that is the meeting that was held on the 28th of November, Gauteng had a mandate to support the bill, and only Western Cape opposed the bill. What should we make of that?
Thank you, Justice Mhlanga. Firstly, as to the pleading point, it is correct that the Western Cape said only 1 or only 2, I can't remember, went through the process and submitted a report. In response, the respondents proved that certain of them had indeed done so, and we accept that. But the fact remains that 2 did not comply. 1, Gauteng, because there was no report at all, and 1, Western Cape, because there was no opportunity to submit the report until it was too late. So we accept that we were incorrect in respect to some of the provinces, but the fact remains, as we alleged from the outset, Gauteng and Western Cape didn't do the job. Then, as to the vote of Gauteng at the meeting of the 28th, and for that matter, the meeting of the 21st, it also supported the bill. We accept that the Gauteng representative, Mr. Bacha, voted in favor of the bill, but he did so without ever having reported without any report having ever been submitted to the Select Committee, either in writing or orally, as to what happened in Gauteng. It remains his vote, but the public participation process in Gauteng fails, and when it fails, then the process fails.
Now, Section 65 of the Constitution says that except where the Constitution provides otherwise, B, all questions before the NCOP are agreed when at least 5 provinces vote in favor of the question.
Yes.
Now, here we know that 8 provinces voted in favor of the bill. Would that be in accordance with that section? And if not, how should we consider this, because now one has to look at the entire process holistically and not look at perfection per se.
Thank you, Justice Mlantla. Yes, indeed, 5 votes are sufficient to carry the day. But you can't vote. The Select Committee is not entitled to move to a vote and to decide this question until there's been a public participation process. That's what Section 72 of the Constitution says. It must promote public participation, and this court has explained that in Doctors for Life, Lemosa, Mogale, etc. So they are not competent to cast a vote. They're not in a position to cast a vote until the NCOP has complied with its obligations in terms of Section 72. Otherwise, one could have the absurd situation that a small group of provinces could effectively hijack the process and say, well, we're going to vote in favor. Let's not bother with public participation in 4 provinces. We'll just do it ourselves because we've got 5 votes. You can't, as it were, hijack an unlawful process and say, well, it's lawful because 5 of us are in favor of it. Can't do it like that.
The province was granted an extension. I can't recall now the dates, but it appears that there was some delay on the part of the province. Should that not be taken into account?
Yes, Justice Mlantla, but the delay is explained. It's explained under oath by the person in position to know who's the chairperson of the standing committee in the province. He explains what happened at the meeting in Paarl. He explains what had happened in the other meetings. He explains that they were inundated with requests for further public hearings. He explains that he discussed it with the chief whip. He explains that they decided they must have further hearings, and they went ahead and did so, and they informed the NCOP and asked for more time. Those are all undisputed facts.
And in one particular instance, in fact, the province wanted to conduct other hearings in respect of 3 locations,
Yes.
where hearings had already been
With
conducted.
respect, no, Justice. They've been conducted in nearby towns, but not in the same places.
Not in the same places?
Yes.
Because my reading of the respondents' papers was that in 3 places they had been conducted.
No, they've been conducted in that district, but not in the same towns.
Mr. Butlander, I want to talk about the timetable and just expand on the question that Justice Mlantla has just put to you. I think you'll accept that if you talk about reasonableness and flexibility of the timetable, it's a two-way street. The NCOP must be reasonable, but so too must the legislatures. Otherwise, the one thing won't work. Now, Justice Mlantla said to you she can't recall the dates, but let me give you the dates and hear what you say about them. On either it's not clear to me on the record, but either on the 20th or the 22nd of June of 2023, there was a timetable agreed to, and again on the 2nd of October 2023. Now, on neither of those 2 occasions did the Western Cape object to those timetables. Am I correct?
Justice Majid, can I qualify what my answer? There was a timetable agreed to on the 22nd of June 23. It's not clear whether there was in fact a meeting held on the 2nd of October. Mr. Pretorius points out in his affidavit that there is the NCOP produces a report on its activities. It reports on all the activities, all the meetings it held. There's no meeting listed for the 2nd of October. Secondly, there are no minutes ever been produced to the 2nd of October. So we don't know what happened on the 2nd of October. It's raised in his affidavit and not responded to. What's this? Secondly, there's the affidavit of Ms. Allen. Ms. Allen is the official of the Western Cape Provincial Legislature, and she explains the efforts she's made to find any record anywhere of the meeting of the 2nd of October, and she can't find it. But so one doesn't know really what happened on the 2nd of October, if anything. But with respect, it doesn't really matter a great deal, because by then things were well in progress. The the question of a meeting, on the meeting of the, I'm sorry, I've lost my train of thought. You ask, Justice Majid, you say the Western Cape voted in favour at the meeting of the 2nd of October.
Western Cape had no objection to the timetable.
Yes. One of the peculiarities of the NCOP system is that the chairman of the Western Cape representative was the chairman of the meeting, who was an ANC representative. So,
Just say that again.
the chairman of the select committee, who supported it and was the Western Cape representative at that meeting, was actually an ANC representative on that committee. So one doesn't know what was going on there. One just doesn't know.
Quite disconcerting, I must say.
It is quite disconcerting. And he talks about my wearing different hats and so on.
Who's that? Can you give me a name?
Mr.
Ndavo.
Njadu. Yes. It is quite disconcerting, but Mr. Pretorius, who's from the Western Cape legislature, says, we were never told about any of this. Nobody ever told us.
Can I just ask you this? You see, why I'm asking about those 2 dates, the one that's pertinent for my purposes of questioning is the latter one, the 2nd of October one. Now that comes from Mr. Njadu's confirmatory affidavit.
Yes.
Because why I ask you if, and I'd really like to hear what Parliament in particular, but even the Minister says about it when they argue, if there was, let's just work on the hypothesis, there was a meeting on the 2nd of October. And it's a hypothesis. I know what your case is, but it's a hypothesis. Let's postulate this position that there's a meeting on the 2nd of October, they agree to a timetable, Western Cape doesn't object. And then on 6 October, 4 days after that, you ask, you raise concerns about the timetable and you ask for an extension because you want to have hearings in these 3 towns. And you're right, those 3 towns were in proximity to where the hearings had earlier been. I know it was in the Garn Route and Hermanus, Overberg and so on. But they were like 50 k's away and you said those people didn't get an opportunity to go there. But the problem is, if all of that is correct, and I hear the problem with Mr. Njadu's position, then it means that 4 days after having agreed to the timetable, that's the case that Parliament puts before the court. You raise the concern then belatedly.
With respect, not quite as simple as that, Justice Majid. The Western Cape Provincial Legislature, which was the body which was conducting the public participation on behalf of the NCP, never agreed to what happened supposedly on the 2nd of October. They weren't told about it, they didn't know about it, and they thought there was still time. One has to distinguish between the Western Cape representative in the select committee with his own party affiliation. I don't want to make too much of it, but it is a disconcerting situation. And what was being done in the provincial legislature, which was the body that was doing the public participation, it did not know, it's uncontested, that it did not know about the supposed decision of 2 October. Far from agreeing to it, didn't even know about it. And it came forward, and said, please allow us more time for these further meetings. That's what we think is necessary.
You say it's uncontested.
Yes, well, Mr. Pretorius has made his affidavit, and there's no dispute about that.
I see what you mean. See, they make the point in their written submissions that you'd actually agree to the timetable on the meeting of the 2nd of October, and for that submission they rely on Mr. Njadu's confirmatory affidavit. But I hear what they say. I hear
It's Mr.
you say
Njadu.
you have no knowledge of a meeting.
Mr. Njadu who agreed, not the people who were doing the public participation. If somebody, what is absolutely clear with respect, is if someone had said to Mr. Pretorius or the Chief Whip in the provincial parliament, on the 1st or the 2nd of October, we're going to go with this final timetable, they would immediately have said, no, we want more hearings. We've already decided that, and we're going to write you about that. They had decided that before the 2nd of October.
I should have asked you earlier, but we were asked yesterday by the transcribers that when one of us speaks, the other one was switched off. I know it's difficult. I'm not used to this. But Mr. Butlander, I'm very concerned about this. But so let's take worst case scenario, not for you, for the other side, for the respondents. Let's say there in fact wasn't a meeting. This is contrived, and if it's true, it's in fact perjury. It's a sworn It's untruths.
I'm sorry, that's why, I'm sorry to interrupt, that's why we are very careful what we say about it, because we realize it's a serious allegation. We don't allege perjury, we just say, where's the evidence of the meeting? None has been produced.
All right, let's soften it. Let's say there was a meeting, but you were never informed of it. Let's work on this position. The effect would be then that your request for further public participatory hearings was based on the lack of knowledge that the timetable had been agreed to. And that would, I suppose that would strengthen your case to some extent.
With respect, that is so, Justice Majid.
I just want to
No,
continue.
with respect, that is the fact. That is an undisputed fact. He says, I didn't know. No one ever told us.
Now, continue with the timetable. You complain about the rigidity of the timetable, whereas Parliament says there was a great deal of flexibility built in it. And Parliament's case is this, and I want you to hear you on this. Parliament says that it adjusted the deadline for the submission of written comments on the bill from 1 September 2023 to 15 September 2023, in other words, by two weeks, and that decision was taken on 21 August 2023. Is that correct?
That decision was taken, once you accommodate the Western Cape, it was taken because they hadn't received the documents which they needed from the department. The submissions hadn't all been considered.
Yes, I'm speaking now generally.
Yes.
I'm saying to you that this is their case, that there wasn't rigidity. Then there's a 2 October thing about which there's a dispute. But they say on 19 October 2023, they again adjusted the timetable for their internal arrangements. They needed to prepare stakeholder response report. You accept that?
Yes, to suit their needs, they adjusted the timetable.
We're just talking about flexibility now. I'll get to the Western Cape. Then on 31 October 2023, they say they adjusted the timetable for a third time, again for their internal needs. That's common cause. And on 7 of November, they postponed deliberations to the 9th of November for the stakeholder response report. You accept that too? Now, can I ask you, they say that Lamosa and Doctors for Life are distinguishable. And they say that in Lamosa, there was absence of participation, complete participation by some provinces. Why do you say that Lamosa and Doctors for Life are on all fours with this case?
Justice Majid, we say that because no two cases are identical as to their facts. But the essence of the case in Lamosa was that there had been no effective public participation in certain provinces. Here, there has been no effective public participation in 2 provinces. And the defects differ from case to case, but it remains a fundamental defect, no effective participation. To that extent, they're on all fours.
Although you must, based on what I've just put to you about the timetable having been moved, you must, I suppose, concede that in Lamosa, there was a very, very rigid adherence to the timetable. There was no movement at all in Lamosa, if you look at the facts. Here, there was some movement, whether it be for internal arrangements or for external requests.
Yes, they adjusted it to meet their needs. And so to that extent, there was some flexibility. But the problem is, at the end of the day, there was a closing date put, the end of 2023. We have to finish this bill by the end of the calendar year. And that's never been explained. And that's the reason why the chair of Mr. Njadu says to the chairperson of the NCOP, we can't extend it further because we won't finish during 2023. We say that is a rigid date, it's a fixed date, which he says is immutable, and there's no explanation offered for it. Secondly, if the real reason is to finish in the session, then we're directly in Lamosa territory. Well, why? Why do you have to do it in this session? No explanation offered. And
Just
so,
last-
so I'm sorry to interrupt you. So there was some initial flexibility, mainly to be fair, to accommodate the needs of the committee. But they imposed immutable deadlines which were unjustifiable and which they've never attempted to justify.
And then just lastly, is there any authority that negotiating mandates have to be considered together, or you say that's the ideal position?
Well, that's how the rules work, Justice Majid, and that's at the heart of the process, because by the time the final mandates have been arrived at, it's too late. But the negotiating mandates is where each province comes and says, this is what we think, and the others say, but what about this, what about that, what about... That's where this debate, which this court has emphasized, takes place. And if you don't have that, then the process can't work.
But Parliament's rules is not binding as far as I know the law.
I think, Justice Majid, they are binding, but the Parliament is entitled to deviate from them under certain circumstances. But the essence of it, it's not really so much a matter of rules. It's a matter of the purpose of the exercise. And the purpose of the exercise explained by this court is that the provinces get together and, having heard what each of the others is thinking of doing, says, but I think you should reconsider. And what about this and what about that? And can we reach agreement on this? Can we compromise? What can we do? And then it goes off for final mandates.
Yes, thank you, Chief Justice.
Thank you, Mr. Budlander. I hope I don't canvass some of the terrain you've already gone through, but I understand your case has a relatively narrow focus, but of course there isn't to be peace. We don't sanction in the court's piecemeal litigation on issues. So can we understand from your case that there was sufficient material made available to the public and to allow public participation in the provinces?
Sorry, somebody coughed. I didn't hear it. Sufficient information?
Sufficient material, whether as to the benefits, the cost of the NHI and so on, made available to the public and to the provinces to allow public participation to occur and enable the province to engage reasonably on the topic.
Justice Savage, let me put it this way. We do not raise the objection that there was not sufficient information.
Thank you. And then just secondly, on the adoption issue, I take it that if the decision to adopt was taken on the 21st of November, then whatever took place after that, there can't be a second adoption. So the submissions that were made, that's a secondary submission, as it were, by you, in the sense that an adoption decision had already been taken as of the 21st of November.
With respect, yes, Justice Savage.
And then thirdly, how would you suggest then that, what sort of reasonable steps would one have to look at to stop a sort of filibuster situation taking place, where a province said, we're not adhering to this timetable, we're going to hold X number of further public hearings, and therefore delay processes, perhaps illegitimately so?
Well, it will be a question of reasonableness. Where there is evidence of a public demand for further hearings, further opportunities to participate, we submit that Parliament or the NCOP ought to lean in favour of accommodating it rather than limiting the opportunities for participation. But where you can say this is a filibuster, you can see the filibuster, it's an ulterior purpose, then you may take a different view. But you can't, take that position in this matter.
And then fourthly and finally, my question simply on remedy is that given the extensive process in the National Assembly and the amount of money spent on public participation in that stage, would it not put form over substance if one was to say that the entire process had to begin afresh?
Justice Savage, it's a difficult question because the precedent points in the other direction, but it doesn't point unforgivingly or unremittingly in the other direction. It says it must go back to Parliament to do the job properly. And certainly we submit that that would be a relevant consideration in determining what is the just and equitable remedy.
Mr. Butlander, to your left. Yes. Can I just get your submission on why, on the different roles of the Houses of Parliament, and why the public participation processes can or cannot be looked or considered comprehensively in the end, given that representations would have been heard from people and parties from the provinces in the National Assembly PP process, why that's not sufficient, and why this NCOP process has to be considered on its own. What is that importance? And it is an issue that I would like to, speaking for myself, hear from all the parties. Thanks.
Thank you, Justice Tambuza. I will give you, if I may, references to the judgments in reply. But the principle is this: the purpose of the exercise is different. The purpose of the exercise in the NCOP is to consider the interests of the provinces. And the court has explained that that is a specific function of the legislative process. That's why we have an NCOP. You might as well say, why do we bother? We bother with an NCOP because the provinces have a particular role and function in our constitutional order and in the legislative process. And so what the court has said, and I'll give you, if I may, in reply, the passages. The court has explained why what the NCOP does is important, and you will see that it is something which is different from what the NA does. It's about bringing the provinces together to share and to enable the provinces to have their own impact on the process of legislation. But I will give you the passages in reply, if I may.
And when you do that, also give me more about if that process in the NCOP happens to be flawed, either considerably or minimally, why can't one have regard to that process? Yes. And also, in this instance, in particular, why that wouldn't be?
Yes, I will address that too, because it's part of the same question, really. Thank you, Justice Tambuza.
Mr. Butlander, just one question from me. Would it be fair, would my understanding be correct to say that the challenge in your matter boils down to this, that in respect of Gauteng, when we consider the issue, there is no evidence that the contribution that the public made filtered through to the NCOP, and that in respect of the Western Cape, although it filtered through and was tabled on the 28th of November, the evidence suggests that it was a mere formality. It was not considered, and also it could not influence other provinces because there was a vote the following day. So there was no opportunity for the provinces to engage with it.
Justice Nuka, those are our submissions. That's, with respect, puts the finger on the fatal flaw in the process.
This may be the right time to take the adjournment, not so. It's 25 past. We'll come back in 15 minutes, do the arithmetic.